against criminals and so as we have stated before, by popular demand, by majority rules. So we're gonna start the process now of delivering word for word, read through the case that is before the course with Jayman. We have already, you know, we have told you about the various motions his public defender had filed for him, and the latest documentation that were filed for him when he went to court was demand for disclosure of impeaching information, file notification, assistant PD assignment, that means public defender. Another document that they had filed is file defense notice of intent exercising Miranda. That means he don't, Jayman is saying that he's not talking to the police. That's what the, the public defender had filed with the court. And there's another thing that they had filed is file discovery, file defense demand for discovery. So they want to investigate to find out if they can gather any information about the case per se that they can use it, to exonerate him of the charges that he has been charged for the double murder in South Florida. So as I said to you, I'll give you in details because I know that most people do not have the time to read, especially when you have to work. Some people don't have the time to read, and some people do not like to read. After 5 seconds, they're like goldfishes. Their brain start to tell them to do something else. But you have some of us who love to read, so knowledge is power. So we're gonna continue to read. But it doesn't mean that because somebody do not read or doesn't read, that makes them that person illiterate. You know, it's just some people learn differently. Some people learn visually, and some people learn by reading, and some people learn auditory. So the auditory is like the way I'm talking and you're listening. We respect each person, and we appreciate those who have been supporting and continue to support this channel to grow, to become a force to reckon with, because our aim and our goal is to change the mindset of the people in Jamaica, and for us to have a better place, a better community, for our people to live, work, and raise their family. We do not believe that criminals must get any slack or anything like that. So the first, so that the case with Jayman, it's the state of Florida, which is the plaintiff, versus Jareem Shelton, who is the defendant. And the case is in the circuit court of the 17th Judicial Circuit in and for Broward County, Florida. Most people who are from Jamaica, they would call Broward County Fort Lauderdale. That's how it is. And back in the 80s, even Broward County used to have the same 305 numbers. Yes, 305 year code. Most people don't even know that who visiting or living in Broward County, recently. But that's how it is until in the early 1990s. That's when the era code changes. Um, Changes in Broward County to 754 and 954. So this is the document that his public defender had filed with the court, and its demand for disclosure of impeaching information. Come knows the accused Jareem Shelton, otherwise known as Jayman, by and through his undersigned counsel, that means the public defender, and demand the state of Florida to reveal the following. So this is what they want the state of Florida to reveal to them. One, all material information in the state's possession or control, constructive or actual. That means it's either they have constructive possession or actual possession. Actual, it can be, yeah, so the public defender wants the state of Florida to release all these information to them. All material information in the state's possession or control, constructive or actual, that tends to negate defendant's guilt. That means they want the public defender wants a court to supply them with all the necessary information that can prove that Jayman is guilty, like video recording, eyewitness statement and stuff like that. But those address and names will be blurred out, for redacted for protection of the witness. Two, all material evidence or information in the state's possession or control, constructive or actual. That it is probably material and else culpatory, regardless of whether such information is deemed to be the work product of the prosecutor or otherwise subject to discovery as a public record. So they want in most cases in America, especially involving, yeah. So the reason why the defense is saying that they want all exculpatory evidence, regardless of whether such information is deemed to be the work of the product of the prosecutor, because in America, when somebody is black, most of the times what the prosecutors have done, they've done it, they have done it to every race of people, but black people most of all, evidence would be there that exculpatory, and they will still hide it from the from the defense, and it will take years for them to to discover it. I don't know why the prosecutors, if they don't believe in justice, but that's how that's how when people are wicked, that's how they treat others. If you hate people because of their race, and that's how you're gonna treat them, which is wrong, because all of us, we are human beings, because nobody blood is white or yellow or pink. Every one of us blood is red. So we should treat people as such. So the third thing that they want from the court, any oral, written, or recorded statement made by any person to the police, to the assistant state's attorney, to a victim advocate or other employee of the office of the state's attorney. The state attorney, or to the grand jury. So no year now, or to the grand jury, because I've been telling people about grand jury, and they think that it was hyperbole and I'm trying to get views, but I'm just telling you guys as it is, because my credibility, my character, my honesty is always on display. So I have to protect it, because that is what made me. What I am known for. That's why some people say I'm an informer and this. Why I don't care about nothing about that. They cannot say I'm a thief or am I a liar. That's the most important thing. You understand? You must always, anything that you're doing must can stand the test of time. So they want the grand jury that tends to establish the innocence of defendant, or that tends to impeach the credibility or contradict the testimony of any witness whom the state will call during this case. So what they want to say, they want to the character of the witness, like, so basically, what is going to happen with Jayman is going to reach a point where Jayman is go whoever take the plea deal and decide to become crown witness against the other, that's a person whose credibility, the public defender would impeach. But cut a long story short, in America, it's people, they will call snitch. They're the ones that always testify for the state and the federal government and send the others to prison. So that's how it works. American system is totally different from Jamaican system. So that's why American, whenever they arrested and charge someone, whether in its states or federal court, the conviction rate is 90%. People normally take plea deal, because they know if they know that they're guilty, and if they go to trial and find them guilty, they're gonna get like 5 times the amount of time they would receive in court. So that's how the state and the state and the federal government have that's leverage over people who commit crime because they have you already, so it's just for you to, give up the cookie. You understand? So, four, any report made to the police that tends to establish the innocence of the defendants or tend to impeach the credibility or contradict the testimony of any witness whom the state will call during this case. So they want all persons involved in the matter, who have given any statement or anything like that to the police. So as we continue journey five, the names and addresses of witnesses who might establish the innocence of the defendant or impeach the credibility or contradict the testimony of any witness whom the state calls as a witness during this case. Six, any information or material that tends to establish innocence of the defendant or impeach the credibility or contradict the testimony of any witness whom the state calls as a witness in this case. Seven, any scientific or medical report that tends to establish the innocence of the defendant or to impeach the credibility or contradict the testimony of any witness whom the state calls as a witness during this case. Eight, the substance of any and all statements, agreements, offer, or discussion had with any of the state's witnesses or a suggestion of leniencies, compensation, assurance not to prosecute, assurance to proceed only on a certain case, on a certain causes, or any other offer to benefits accruing to said individual whatsoever in exchange for their cooperation, assistance of testimony in the trial hearing. So what the public defender is saying that they want any statement, any agreement, because there's a thing that that the other people who are charged most of the time is people who commit crimes with the other defendants that will sign a plea deal that they will testify against the co-defendant so they get less time. That's how it works. So that's why they tell you that the smart criminals will tell you that if you're going to commit a crime, make sure you commit it by yourself, so that the only person who can send it to your prison is yourself. You understand? So people who are experienced criminals know that, but people know that they feel like committing crime with other people is helpful, but this is the part that helps send you to prison. That's why it's best not to get involved in crime. Always do the right thing. You understand? Nine, any and all consideration or promise of consideration given or made on behalf of the government witnesses by consideration defendants refers to absolutely anything of value or use, including but not limited to immunities, grants, witness fees, special witness fees, transportation, assistance or favorable treatment with respect to any criminal, civil, tax court, or administrative dispute, and anything else which could arguably create an interest or bias in the witness in favor of the state against the defense, or act as inducement to testify or to color testimony. So what they're saying right here, that they want to know if anybody receive any immunity and they're getting immunity grants, are they getting anything of value, they're getting money, they're getting transportation, they're getting favorable treatment. So the defense want to know all of that. 10, any and all prosecutions, investigations, or possible prosecution pending, or which could be brought against the defendant and the witness, and any probationary parole or deferred prosecution status of the witness. That means if one of the so-called witness is on parole for any various crime that they have committed, the defense want to know about that. They don't want them to cut it, the court to hide that from them. They want to know because they're gonna say if that person is on parole, he has every reason to lie on Jayman because he wants to get up. But remember, Jayman is on parole, immigration parole in the United States because he had filed for his status, seeking refuge in the United States as a person who witnessed a triple murder. So he had to flee Jamaica, Montego Bay, Jamaica, leave a murder case. And he has a murder case in Jamaica in which he jump, you call it jump bail, and then he's in America seeking asylum. And in America, he commits double murder. 11. Any and all records and information revealing felony conviction attributing to this witness. So they want to know if the witness have any criminal conviction. So if the person have any criminal conviction, based on that, that person can be discredited. Say, yeah, you're a criminal. You don't have no ethics, honesty, or decency about you. You're just a career criminal. So they want to know that to see if it will work in court. 12. Any and all records and information showing prior misconduct or bad acts committed by the witness. So they want to know if the witness or witnesses, if they have any dirty laundry, in their closet, that these people are bad actors. As grounds in support of said motion, the defendant would allege as follows. The evidence of any such offer or representation which have been made by the state or which the state will make at any future time of any witness for the state should be discoverable pursuant to the due process clause of the United States Constitution Amendment 5, Amendment 7, and the Florida Constitution, Article 1, and the withholding of any such evidence constitute a denial of the accused hearing of his constitutional protected rights to due process and fundamental fairness, as well as his rights to effectively cross-examine and impeach witnesses against him as guaranteed by the United States Constitution Amendment 11 and Florida Constitution Article 1, Section 9 and 16. Wherefore, defendant moves this honorable court to grant this motion. I hereby certify that a true and correct copy of the foregoing has been furnished by e-service to the Office of the State Attorney at, and I put the email address, that Florida Broward County Courthouse, Fort Lauderdale, this November 3rd. And it is signed by Public Defender Gordon Weeks, 17 Judicial Circuit. And it is signed by Anna Paulina Guerra and our Florida bar number, Assistant Public Defender. And she's the attorney for the defender. So Gordon Weeks is the public defender, is the guy who's in charge. As usual, once it reaches a certain time, we have to stop because, most people, attention span is like of a goldfish. After 5 seconds, they want to do something else. So let's just pause it right here. Like the video, subscribe to the channel, share the video. Most importantly, comment on the video. And there's a WhatsApp group for members of the Jamaica Young Police channel to converse with each other about anything that has to do with crime. Because we as a channel, we hate criminals and we hate them with a passion and terrorists. Have yourself a beautiful day. Part 2 will be coming up shortly. Have a nice day. Peace. For the police, the state to supply them with such information. So as we continue,